Ready to open a probate estate? Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 558, the application for informal probate and appointment of personal representative. This form, SCAO, SCAO for State Court Administrative Office, PC for Probate Court, Form 558, is readily obtainable, and you can contact my office. We'd be happy to give it to you free of charge. Now understand, this form is used to begin a probate process. It is an informal probate process as compared to a formal proceeding with a petition for probate. So you have to really carefully understand when you'd want to use an informal administration versus a formal appointment of a personal representative. There are significant impacts by virtue of proceeding through an informal administration versus a formal administration. So understanding the difference is really the first step before starting and embarking down this path of an informal probate. The application for informal probate is guided and created by various statutes and court rules as reflected by the floating yellow arrow in the bottom right corner. These statutes and court rules are complicated, so please read through them and work with a skilled, competent probate lawyer who understands how to navigate through the probate process. Also understand that this is just step one of a multi-step process, a multi-month, sometimes year-long or years-long process of probate administration. We urge you to work with a lawyer because navigating through this process is not intuitive. There's no rule book or guidebook that will show you each step of the way, and the court staff can't help you through the process. So work with an attorney to be assured that you understand each step of this process. Now, there are many videos that I've put together explaining the probate process, the timeline, and so on. You can use these to give yourself a better understanding of the probate process, but don't rely on them solely. Work with a lawyer. Let's work our way through the particular form. This application for informal probate is started by completing the county in the top left corner in the blue rectangle that identifies the county upon which the individual who died was domiciled. Now, the word domiciled is a little odd for some people because most people think of residency, but domicile has a particular meaning under Michigan's probate statutes. So understand when domicile or how to define the term domicile. Probate can also occur in the county in which an asset exists in the event that the person died out of the state of Michigan. In the top right corner, there's going to be a file number. Now, you'd think that you'd have to put something here, but this is actually left blank because the court is going to give a case number, a file number, when you fill out this particular application for informal probate. As you can see from the title, it's an application for informal probate and or the appointment of a personal representative, testate, intestate. What that means is with a will or without a will. Now you can open the estate, you can appoint a PR, you can submit a will, you can proceed intestate. These are all decisions that are being made at the commencement of this informal proceeding. The idea of informal probate is that generally this path is used when the family is in harmony. Everyone is getting along well. There are no issues that would need to be litigated. There's no disputes over the will. There are no disputes over determination of heirs. There's no fighting or dispute resolution that needs to occur. Now, we understand that even though you start informally, you could proceed to a supervised administration and a formal process. But this informal process is really designed for minimal court intervention. So the idea is that although you are filing and presenting things through the probate court during the probate administration, the court really is not involved unless necessary to get involved because of some particular issue. So again, very particular use of this process. At the top, you identify the name of the decedent, and we typically recommend that you use the information that's contained on the death certificate and any aliases that the individual may be known by. In addition, the name of the applicant, and the applicant can, under Michigan statute, can only be particular people, so there's a prioritization of the appointment of a personal representative and who has the standing to be an applicant. Again, the court rule and statute guide and direct that particular definition. Below that, the relationship. So are you a nominated personal representative in the will? Are you a creditor? Are you an heir of the estate, the surviving spouse, a child? What gives you the right, the standing, to be the applicant in this particular matter? The next is basic information about the decedent. And this information generally comes right off the death certificate. The date of death, time if known, date of birth, and the last 4 digits of the Social Security number of the person that died. Again, the domicile information, and again, it usually corresponds with the death certificate, but not always. We know that some people live in different places. For example, they may live half the year in Michigan and half the year in Florida. We also know that some people are transient. They may be living in a nursing home or maybe in an apartment for a period of time. So this term domicile can be tricky to solve, and again, seek guidance if you're unsure. The county and the state of that domicile. As we move further down, you have to show proof of death. So again, is a death certificate attached? Or is there some other proof of death that's being provided, like a medical examiner, coroner report, or other form that the court would find acceptable to show proof of death? Section 4 is really an important section here. It identifies with reasonable diligence the names and addresses of all of the people that are identified and entitled to receive notice of the application through Michigan statute and court rule. So again, under the laws of intestacy, you have to know who has the right to notice. Now, the part that I want to just caution everyone is often we get phone calls and they'll say, well, there are 3 children, but 1 child has not been involved in dad's life, or we don't know where that person is, or they don't have a relationship at all. That's not how the statute works. The statute doesn't measure the quality of the experience or the relationship, but simply whether they were born into that relationship. Now, there are some technical rules here that also apply, but you don't get to decide whether somebody had a good relationship or a bad relationship and then dictate that information on this form. You have to identify all the children. And in fact, some people will say, well, somebody died a few years ago. Well, if they died, there are statutes that dictate whether their children are entitled to receive notice instead of them. So again, really important to understand who has the right to the information and providing correct and accurate information regarding their whereabouts. So with reasonable diligence, the name and address. You can't just say, I don't know where they are. You have to use reasonable diligence to locate them. In addition, the relationship is identified. Again, are they an heir? Are they a devotee? A devotee means that they're named in the will. And then again, their age if they're a minor. So again, the court's trying to determine whether somebody is a minor or an adult here. Below that is any of the individuals who are under a legal disability. There are particular rules that protect minors and people under legal disabilities to be assured that they're given appropriate notice and representation. Again, a lot going on here as it relates to the prioritization and identification of the heirs and or devotees within the informal application. The next section identifies the venue piece. We spoke about this a little bit earlier. Venue is proper in this county because the decedent was domiciled. So you check that box if that's the case. And that's the most common scenario. And then the other is that the decedent was not domiciled in Michigan, but venue is proper in the county because the decedent, property of the decedent was located in the county at the time of death. So again, understanding the difference here. So an example would be, let's say they died they were domiciled in Florida, but they had a piece of real estate in the city of Detroit. In that particular case, venue could be proper in Wayne County because of the asset being located there. Let's work our way onto the back side of the application. Again, a lot of information here about the will now, whether there's a will or no will. And we use the term intestate to determine or to define when there is a person that died without a will and intestate with a will. So this concept of that the decedent under section 6A, the decedent died intestate, and after exercising reasonable diligence, I'm unaware of a testamentary document. That's 6A. Now again, B, C, D identify whether there's a will, or if a will is lost or destroyed, whether there's a will in a codicil. All that information gets contained there. And again, you don't get to decide the validity of the will. You don't get to decide, well, I'm not so sure Dad understood what was going on in that will. You have a duty to present to the court any unrevoked testamentary documents to the probate court. So again, that's identified here. And an important consideration is in informal administration, the will is actually not formally admitted to the probate court. So the timelines relating to the contesting of the will are quite different than in a formal manner in which there's an adjudication of the admission of a will. So if there's any issue about the will's validity, or if you need a court order adjudicating the admissibility of the will, then you wouldn't want to go the application process. You'd want to go with a formal adjudication of the will, maybe through a petition for testacy or for formal administration. So again, an important consideration as it relates to the admissibility of the will. The next is that under 7, there's an identification. To the best of my knowledge, I believe that the instrument subject to the application where validly executed is the decedent's will, but I'm unaware of any instrument revoking the will. So again, 8 identifies if this estate had been previously opened in another county or state. This can occur with ancillary administration, or if, for example, you opened in Florida and then 10 years later you realize there's an asset in this state and then you're opening again. So again, identification of whether there's any other jurisdictions that were handling probate or any other venues that were involved here in Section 8. And it lets you identify the court itself. As we move further down the document, this is where there's a nomination. The nomination of who's going to serve as the personal representative, who is going to be in charge of administering the estate and carrying on all the responsibilities, the fiduciary responsibilities of doing so. Now, under Michigan law, there is a pecking order, a prioritization of the appointment of a personal representative. So understanding that statute to identify whether the person you're nominating has the highest or an order of priority of appointment of personal representative. That's what they mean here when they speak about the nomination by the applicant, and then who is qualified and has the following priority for appointment. That's Section 9. So you'd identify, are they nominated in the will? Are they, for example, the surviving spouse? And then their address. Section 10 identifies any person that has equal or higher priority of appointment. So again, this is the provision to give notice to those people that may have equal or higher order of appointment under Michigan statute to the right to object to the nomination that may be put forth in this application for informal probate. So again, Section 9 is the nomination. Section 10 is an identification of anyone that has equal or higher order of appointment. Now, if those people have equal or higher order of appointment, then those people can renounce through a renunciation process. And I've done a YouTube video explaining this basic process. The applicant can use a notice of intent process that seeks informal appointment and gives the requisite notice to give those people the right to assert their rights and either actively object or passively say, we don't care about the opening of the estate, or we don't mind the application for informal probate moving forward. So again, either renunciations of those equal or higher order of appointment, or notice of intent to seek informal appointment has occurred and you've provided proof of service. So this is part of the larger package that goes with this application, as well as a testimony that would be included in this larger package to begin this probate administration through informal proceedings. Number 11 identifies whether the will, if there's a will, expressly requests that there's an appointment with a bond. And we don't see that often, but a will, usually we see that the testator in the will says, I don't want the personal representative to need or require a bond, but sometimes it is a requirement within a will, and that Section 11 is for that particular purpose. Section 12 is whether a special personal representative is needed. And again, it doesn't happen all that often in an application context, because often in an application process, the appointment occurs quite quickly, rather than it being scheduled for a hearing many weeks or even maybe months later. The application often is filed with the court, and then a personal representative gets appointed quite quickly. But a special personal representative may be appropriate in certain contexts, and that Section 12 is for that particular purpose. And maybe there's a limited role that the special personal representative needs to be involved in, or a limitation of their particular duties on behalf of the estate, but not often used, that checkbox number 12. As we move further down the document, this is where you're making the request of the court through the application. Again, a lot of repetition here. Is there a will that you're informally asking the court to probate? And again, very important distinction here. You're not admitting through a court order. You're informally probating the will. 14, informal appointment of a nominated personal representative with a bond or without a bond. And a bond is a bond is a guarantee of performance, and it generally is with a requirement for a surety, which is generally a bonding company or insurance company that is guaranteeing the performance of the duties of that personal representative. And it's an expense and often a difficult thing to qualify for. So with bond or without bond. 15, the appointment of a special personal representative, as we referenced above under that little checkbox number 12, this corresponds to that particular piece. The next is the declaration that occurs on most of the SCAO forms. It's a declaration under the penalties of perjury that the information has been examined by the applicant and that the information is true to the best of your information, knowledge, and belief. And again, you really should pause here when you read that, because that information, before you sign, you're certifying under the penalties of perjury that it's correct information. And especially as it relates to the will issue, as well as the information contained in the application. Because if you fail to include somebody could come back and say you've perjured yourself, and that could cause you to have exposure and liability. So take that provision very seriously. Accurately reflect all of the people that are entitled to notice under this process. Now again, there's a spot for the date as well as the applicant who is signing this document, completing it, their signature, and then of course on the left side if there's an attorney for that information. This is just page 1 or page 1 and 2 of this long probate process that has many, many steps. And navigating into probate and the informal process, whether it's informal or formal, is daunting. There's a lot that you have to understand, and there are books that are behind me that have the statutes that we spend years studying, and I go back to these books really every single day to look up statutes, to understand the nuances. So we strongly, again, encourage you to work with an experienced probate practitioner to navigate through this probate process. At the Probate Pro, we're passionate about everything probate. If you have questions about the application, informal probate, or any probate or trust related issue, visit us at the Probate Pro or call us at 1-833-PROBATE.